and I head our regulatory team. I've been at Birketts about 10 years, and before that I was in independent practice at the bar in a large regulatory and criminal set in London, where I did a lot of prosecuting and defending in fraud and serious financial crime. This webinar today going to be in 3 sort of phases, which is why seamlessly there are 3 of us from Birketts presenting today. I'm going to be taking the second slot and talking about anti-bribery policies and Bribery Act generally. I'm also today joined by my colleague Dan Irvin. Dan is a legal director in my team at Birketts. He's also a barrister. He's been with us about 5 years or so, and again came from private practice in chambers in London and was involved in a lot of financial crime, both prosecuting and defending. Dan does a lot of work for our international clients in sanctions, and he's going to be talking about that in the latter half of this webinar. Jess Cause is going to kick off in a little bit, talking about antitrust, anti-corruption. Jess is a legal director based in London. She is not, and she wants me to emphasize, a corporate lawyer. She's a specialist financial services regulatory lawyer, and Jess is very experienced in the area that she's about to talk to you about. So I'm going to, now that most people I think have joined, I'm going to hand over to Jess, who's going to lead the way this morning. We anticipate that we'll be talking for about 60, 75 minutes. Hopefully may have some time for questions at the end. If you have any questions, please do put them in the Q&A on the webinar browser. And if we do have time, we'll get to them at the end. If not, we'll email out any answers subsequently. I'll catch up with you in a bit after you've heard from Jess. Thanks.
Thanks, Matthew. Hi, everyone. Yes, so I'm Jess, and I specialise in financial services regulation. So while I'm going to talk to you today about antitrust, or kind of competition law, as we call it in the UK, I'm going to give you a high-level summary of the provisions that you need to be aware of working within a regulated firm. And then I'm going to focus in on the role of the FCA and talk about enforcement cases in this area. So just to start off with, I'm sorry about the very dense slide, and hopefully you can see that, but this is the densest one, and I'll try and get through it as quickly as I can. What is antitrust? You asked us to provide training on antitrust. In the UK, we generally refer to competition law instead of antitrust, and antitrust is really a term to describe the rules that were put in place by government to remove concentrations of power and to enhance competition. Through my research, I found out that antitrust is apparently an early 20th century term that was used to refer to the breaking of trust between companies where other entities went behind people's backs to put in place secret agreements. So that's why the term still sort of continues to be used. And what are the key provisions that we have in the UK? We do have a very detailed framework in the UK to cover competition law issues. And it was actually recently enhanced by the Digital Markets Competition and Consumers Act 2024, which, as you can imagine, regulates our digital markets in terms of competition. While we were part of Europe, we had to take into account the entire European framework around competition law, which has somewhat been retained and onshored, and courts in the UK are bound to ensure consistency with pre-Brexit competition case law, unless there is a significant difference in the way our markets work. So as I said, while there's a very detailed network of competition law, the focus for today are the key provisions to be aware of, which are set out in the Competition Act 1998. So just to start off with, the key bits are set out in Chapter 1 and Chapter 2, and I'm going to start with the Chapter 1 prohibition, which prohibits agreements which may affect trade within the UK and have as their object or effect the prevention, restriction or distortion of competition within the UK. Just some points on this to start with. For Chapter 1 to apply, the arrangements must be between independent parties. So generally, intergroup arrangements are not going to contravene Chapter 1. It does set out a non-exhaustive list of anti-competitive agreements, for example, those that actively aim to restrict competition, such as the sharing of information or fixing trading conditions, things like that. And you may have heard of the terms horizontal and vertical agreements. And generally, what are known as horizontal agreements are regarded less favorably by the competition authorities. These are the types of agreements that are entered into firms that are operating at the same level, such as two manufacturers, as they may involve coordination between competitors. And competition authorities generally accept that vertical agreements, for example, manufacturer and supplier agreements, are not going to generally give rise to competition issues, but there are exceptions. For example, where a manufacturer restricts prices charged by an independent retailer. So for an agreement to contravene Chapter 1, it needs to be one that has an appreciable impact on competition. There's no legislative definition of this, but the Competition and Markets Authority follows European practice on this, which sets out that the parties involved must have certain market shares. And there's OFT guidance. OFT was previous regulator of competition in the UK, which sets out that sort of as a very high level position, each of the parties need to have 10 to 15% of market share. However, agreements which have as their object the restriction or distortion of competition are almost automatically appreciable, no matter the market shares of the participants. There is a very limited immunity from fines when an agreement is between parties whose combined group turnovers in the last financial year do not exceed £20 million. This is just an immunity from fines, however, there's no protection for third-party actions for damages. The other thing is that the CIMA can investigate you and then withdraw this immunity if they deem it fit to do so. So just an example of a type of agreement that might cut across Chapter 1 is a price fixing agreement. These types of agreements actually don't even benefit from the immunity, and they were generally always deemed to be ones that have an appreciable effect on competition. So agreements between competitors to fix prices are often known as cartels, and they're traditionally one of the most obvious breaches of competition law. There is actually an exception to Chapter 1 in very limited circumstances where the benefits of the agreement or the arrangement outweigh the anti-competitive effects, but I think that's going to be in very limited circumstances where that exception applies. So moving on to Chapter 2, this provision prohibits the abuse of a dominant market position which has or is capable of having an effect of trade on trade within the UK. So what does dominance mean in this context? The CIMA again follows EU case law to define this, and the OFT again has issued guidance on the meaning of the term. And the guidance says that an undertaking may be dominant if it possesses a substantial level of market power. And a firm will have this, a substantial level of market power, if it has the power to behave independently of competitive pressures. So you need to look at the market share of the relevant entity, likely need to have about 40% of the market share to be dominant. You need to look at things like barriers to entry and strength of existing competitors and potential new entrants to the markets, as well as customer power to establish if someone has a dominant position or not. So holding that dominant position is not alone unlawful. There must be an abuse of that position for there to be a breach of Chapter 2. There's no definition of abuse, but there's a non-exhaustive list of specific conduct that can constitute abuse of a dominant position. Again, there's a very limited immunity from fines if the conduct is of minor significance. That means the firm's turnover in the previous financial year does not exceed €50 million. Again, the CIMA can withdraw this after investigating a person for breach of Chapter 2. So an example of a type of arrangement that might breach Chapter 2 is where someone has a dominant position and they carry out pricing abuses, for example, excessively high or predatory pricing, such as undercutting a rival with a view to eliminating the market that they have. I would imagine that Uber took quite a lot of advice when they entered the market, because I remember their pricing was pretty predatory at the time. There's also sort of loyalty pricing and discounting schemes to discourage customers from placing business with a competitor. And finally, just a few other elements to be aware of. As I said, the network of competition law is very broad, but I wanted to cover some specific offences in relation to individuals. The financial thresholds around Chapter 1 and Chapter 2 mean that they generally cover body corporates and associations, but the Enterprise Act 2002 made individuals acting on behalf of corporates personally liable for certain activity. So if individuals enter into an agreement relating to a company's involvement in what's called hardcore cartel activity, these are dishonest agreements for competing companies to fix prices, share markets, limit production and supply, things like that. This is a criminal offence, and a person can be put in prison for up to 5 years, and they can be subject to an unlimited fine. And directors of a company who have infringed Chapter 1 or 2 may face disqualification in terms of acting as a director for 15 years. And it's a criminal offence to so act during that time period of the ban. So how is competition law enforced in the UK? The primary regulator in the UK, as I said, is the Competition and Markets Authority. And as I will explain later, there are concurrent regulators for particular sectors, such as the financial services sector. We have the FCA, who can enforce Chapter 1 and 2 prohibitions in their sectors. So the CIMA can decide to investigate and take action where a firm intentionally or negligently infringes Chapter 1 or 2. A lack of knowledge of the law is no defence at all. The CIMA has very broad powers to conduct investigations, search premises, impose measures on firms, order companies to stop acting. And the most common option is imposing fines of up to 10% of worldwide turnover for the previous business year. There is an option for firms to reduce the potential fine by whistleblowing on other members within the arrangement and admitting to the breach. So I'll show some examples of this later on. If you infringe Chapter 1 and 2, there are other practical consequences apart from the CIMA enforcing against you. Third parties have a right to take action for damages and injunctive relief. So what is the role of the FCA? As I said, they are sort of a secondary regulator for competition for financial services. The FCA has actually been set a number of competition objectives by government, and one of them is to promote competition in the interests of consumers. So the consumer element is a very important aspect of the FCA's sort of position on competition, and their view is that poorly functioning competition can cause harm to consumers, firms, and the economy. So that that objective floats above everything they do, all their rule-making powers, things like that. So since 2015, they have had joint powers with the CIMA over the provision of financial services in the UK. And if you're interested in finding out what they are set out in detail in guidance, FG 15.8. They have all the powers that are needed to enforce a breach of Chapter 1 and 2 in FS. This also includes a power to issue a fine of up to 10% of annual worldwide group turnover, just like the CIMA. Only one authority can investigate and enforce at the same time, so they'll agree with CIMA who's going to do that. Ultimately, though, it is the decision of CIMA which regulator is going to take it forward. There's also a memorandum of understanding between the two entities. So what do we see the FCA doing in relation to competition? You'll often see them conducting studies in particular markets to look at market structure and dynamics. They might issue calls for input to see if they need to make new rules to enhance competition and support consumers' interests in a particular area. They may investigate specific anti-competitive behavior. This might be in a particular sector where they feel they need to intervene generally. For example, in home and motor insurance renewals, they definitely made some changes there. Insurers were banned from quoting customers higher prices for renewing than if they were a new customer. The FCA felt that this was very much distorting the way the market was working. Similarly, now firms are obliged to disclose last year's premium and encourage consumers to shop around at that stage. They may also take specific enforcement action against a particular firm for formal breach of Chapter 1 and 2. There's actually very limited examples of the FCA doing this, only 2, and I'll talk about them over the next set of slides. They can also implement regulation to support competition, FCA rules, and the FCA very much sees the consumer duty as part of its enhancement of competition agenda. This element of providing fair value to customers they see as something that helps to regulate competition in the UK. Finally, I wanted to highlight there's a duty on regulated firms to self-report. We all know about Principle 11, the fact that a firm must deal with its regulators in an open and cooperative way and disclose to the FCA anything that the regulator would reasonably expect to have notice of. Senior managers are subject to Conduct Rule 4, which also makes them disclose anything to the FCA that that the regulator would reasonably expect to have notice of. It's sort of a reflection of Principle 11. So a competition issue, a potential breach of Chapter 1 or 2 is definitely something that needs to be self-reported to the FCA. So if you were subject to an FCA investigation for a competition law breach, what would happen? So firstly, the FCA will discuss with the CIMA to decide who is going to take forward the investigation. If it's going to be carried out by the FCA, they will engage in a fact-finding process. They have all the powers that they need at their disposal to do this, to request information. They will come and conduct interviews. They will come onto site. They love a dawn raid. They love the drama of it. So they will go through and gather all the evidence they need and carry out their analysis. And once they have made their decision, they will provide to the firm their provisional findings and something called a statement of objections. They will set out the law, the evidence, their analysis, and their decision. At some point in this process, the firm may decide that they are going to engage with the FCA, admit to the breach, and try to lower the potential fine, which is sort of within their power in terms of competition law. After the provisional findings of the FCA, the firm has the right to make submissions to the FCA around what has gone on. The FCA will then make their final decision, which will set out the penalties they will impose on the firm and also any directions they want to make. This is not confidential, the final decision. Everything else up until this point has been confidential, and it will be published on the FCA website. So you do not want the FCA to investigate you and enforce against you for competition law breaches or any breaches, as there are reputational issues. Finally, I'm going to go through a couple of case studies. As I said, there's two examples of the FCA engaging in competition law investigations and enforcement action. So the first, as I said, was in 2019. So the FCA has actually had these powers for about 10 years, and it's only ever used them formally twice. So the first time was against a group of investment managers, Newton, Hargreave Hale, and River and Mercantile. They apparently exchanged information in relation to an IPO, and this was crucially the price they were willing to pay for the shares and the volume of shares they were going to acquire. And the share price for the IPO was set very soon after these discussions. The FCA said this was definitely an infringement of Chapter 1. The issue price was impacted by these discussions, and it just meant the IPO did not proceed in the ordinary course. These discussions dictated the way it played out rather than sort of market factors shaping the IPO. The investment managers were fined. Hargreave Hale was fined 300,000, River and Mercantile around 100,000, but Newton were actually not fined because they reported everyone else. However, a fund manager within Newton was fined himself about £30,000, and he was dismissed from Newton. There was a very recent case in 2023 where the FCA enforced against couple of firms in Glasgow. They were entering into anti-competitive arrangements where they coordinated the pound to Pakistani rupees FX rates and fixed the transaction fees charged to customers who were transferring money from the UK to Pakistan. Again, they entered into a settlement agreement with the FCA and they admitted to the breach of Chapter 1, so they each received a discount, and I think the total fine was about £150,000. So it's not huge amounts of money here. And what is interesting, I think, with the IPO case is that it's not sort of a significant breach of competition law, and it's possibly something that was taking place here and there. And I think the FCA just really wanted to make an example of this in the practice. Whereas the second example is very much classic sort of price fixing behavior, the classic Chapter 1 breach. So only 2 cases. Apparently there are ongoing investigations, however, and we should see some more enforcement action coming out of the FCA, but it all takes time. So finally, hot off the press, just a couple of days ago, actually, the SEMA said that they are going to enforce against a number of banks for breach of competition law. So this has been handled by the SEMA despite involving financial services, and I think this is probably because the SEMA has the resources needed to investigate these types of things, whereas the FCA is pretty stretched generally, and we know it's quite difficult to get involved with the FCA as they don't have enough people there. So the SEMA has now issued 5 separate infringement decisions against Citi, HSBC, Deutsche Bank, Morgan Stanley, and RBC. So the SEMA has decided that these banks broke competition law by unlawfully sharing competitively sensitive information in relation to the trading of government bonds. And the exchanges actually took place between individual traders over Bloomberg between 2009 and 2013. So it's just quite an interesting point around systems and controls and just having oversight of the individuals who work on your behalf. This wasn't something that took place at director level, at company level, such as price fixing arrangements, things like that. This was a couple of individuals who were sharing sensitive information, and there is a very, very large total fine. So it's just a reminder to have oversight of the people who are carrying on business on your behalf. So yeah, I'm just going to hand over now to Matthew. Thank you.
Thanks very much, Jess. Right, everybody, I'm going to talk about anti-corruption, anti-bribery. So a little bit about what that sort of means, what the Bribery Act is about, some examples of what bribery is and what it's not, and also going on to talk about what processes, procedures you should have in place to ensure that your people and you as a business don't fall foul of the legislation. And so I'll talk a little bit towards the end about the guidance that the MOJ put out not long after the Bribery Act came into force some years ago now, and how businesses have adapted that. And I know from Beverly providing us with some of your policies, you've certainly adapted some of that into your policies and procedures. The offences under the Bribery Act, sort of the failure to prevent offences, which I'll come on to talk about, or offence, which we are seeing now and have seen in other spheres. So obviously you'll be familiar, no doubt, with failure to prevent tax evasion and soon failure to prevent fraud in a corporate sense. To a large degree, whilst they are focused in particular sectors, they came about because of a perceived difficulty over a period of time prosecuting corporates, prosecuting businesses, as opposed to individuals who work within the businesses. Because obviously, as we all know, being part of an organisation, and our law firm, Birketts, is no different, we have to have processes and procedures in place to make sure we don't fall foul of our particular regulator, but also we don't fall foul of anti-money laundering, anti-bribery, whatever it may be. Historically, when the regulators were looking to enforce and prosecute, there was always a difficulty with corporates trying to link the behaviour of the corporate to individuals within it, and to identify individual people who spoke or had the responsibility within the business, the authority within the business, to drive change, to make decisions, and those decisions impacting on potentially the criminality. So essentially, the thoughts behind it were that the UK, over a period of time, started, particularly in corporate financial crime started to fall behind some of its international peers in terms of regulation and particularly prosecution. And so the solution was to come up with, and there was a lot of process behind it, a series of new bits of legislation which put the onus on the corporate entity to do something or else. So in a very general sense, the failure to prevent offences, I'll come on to talk about them in a moment, the corporate is guilty of them unless it can show that it has put those proper procedures and processes in place and they are reasonable and proportionate to the risk that was perceived. So the Bribery Act sort of led the way in a sense in relation to that slight change in emphasis, and it allowed regulators not to worry so much about trying to link individuals with authority in the businesses to the offending behaviour and put the onus on organisations such as you, such as us, to actually have those proper policies in place and to show to the regulators or to the enforcing authorities that we had them if necessary. The Bribery Act, for a Wednesday morning, is quite complicated. This slide originally had the definition of bribery on it, and I took it out simply because it is quite difficult to explain on a slide, and there's an awful lot of words. And so I've taken it out, and what I'll do is try and break it down into very simple terms, because that's much easier for me and much easier for you. It is obviously about somebody, a person, directly or indirectly promising or giving some sort of financial advantage to somebody else. And I'll come on to talk about it in a moment. It's not about a brown envelope full of cash necessarily, although I'm fairly sure that probably still does go on in places around the world and certainly did for a long time. But there are different ways that the offence can be committed. But essentially, it's that person approaching somebody, trying to induce them, to promise them with some sort of financial money or some other financial gain or benefit, intending that they are going to be induced by that benefit, by that money or that financial reward, to improperly perform a function or activity. So in the context of the commercial arena, I suppose the classic example, and I'll come on to talk about it in a little bit, is that an official who has the say-so on a contract is offered a holiday for his family, expenses, all expenses paid, to Australia for a month, let's say, if a certain company gets the contract. So the person making that offer, on assuming that they are associated with the company that wants the contract, is obviously making that inducement, giving that financial gain to the individual who could award that contract, intending that official then improperly exercises their function. So it sways the decision, essentially. So that in essence is what it's about. There are a variety of different sections within the Act, not on the slide, but Section 6 of the Act is specifically relating to foreign officials. So in general terms, very much focused on activity that's obviously happening outside the jurisdiction of the UK, but obviously this is what's called extraterritorial jurisdiction in this Act. So companies and individuals can be prosecuted in the UK for acts of bribery that have occurred worldwide by persons associated with the UK company. So it's illegal under the Act to bribe foreign public officials, as I said a moment ago, sort of offering or promising or giving money or benefits. And that can be directly or indirectly. So you don't have to have somebody going back to my holiday in Australia. The person associated with the company that wants to win the contract doesn't have to go directly to that official. It can be indirectly through another third party, as long as an inducement is given, and as long as the relevant intent is there to make that official act improperly in the course of their function or their business activity. Section 7 is the one that obviously there's individual liability. Individuals can be prosecuted under the Bribery Act, but obviously, as I've said, more importantly perhaps for us as businesses, is the general failure of commercial organisations to prevent bribery. So that is where, as I said a moment ago, somebody associated with the organisation commits a relevant bribery offence. The associated is quite wide, so the person associated with the company doesn't mean they have to be employed at all by the UK-based company, as long as they have an association with it, and that association could be through subsidiaries based outside the UK. It doesn't matter that the company was unaware of what was happening, and it would be surprising if that was the case, or the opposite was the case, because obviously a lot of these activities, these unlawful activities, happen under the radar by their very nature. Bribery is not something that necessarily people would go out and herald, so it's not surprising at all that the company does not need to be aware of it to be prosecuted. But there is a defence under the Act, and that essentially is what I'll come on to talk about in a little bit. If the company can show that it had adequate procedures in place to prevent the offence. And that's, to that point, that was the guidance that the MOJ issued, I think in 2011 probably, which went to that offence, because not surprisingly, following the Bribery Act coming into force, a lot of associations, a lot of businesses and companies said, well, this is all very well, government. You tell us that it's fine if we've got adequate procedures to prevent bribery, but you need to give us a little bit of help as to what you, as the government, and more particularly, therefore, as the regulators or the enforcing authorities for this, and that's the Serious Fraud Office, the SFO, you're going to have to give us a little bit of understanding of what you would deem to be adequate and proportionate procedures. And as a result of that, the guidance came out from the MOJ, and a lot of companies have obviously taken that guidance and either simply replicated it in their policies, or probably in a better way have adapted it specifically to the risks that they see in their business. So as I touched on, how does that particular section affect you? Well, it means that if somebody associated with you commits an act of bribery, so in terms of the slide, that's the person, to obtain or retain business, or to get some sort of commercial advantage in relation to that business, then that is a qualifying offence under the Act. And as I've said there, associated person is understandably wide, and it's meant to be drafted in a wide way. Employees, agents, or other persons who perform services for or on behalf of the business, contractors, suppliers, agents, intermediaries. So it casts its net deliberately wide. And obviously, depending on geographical delivery of your services and the intermediaries or agents you use, then the risk and the processes and policies you have to put in place to mitigate that risk are increased. And so that's why a lot of organizations who work internationally have underlying anti-bribery policies. But as you'll see from what I say a bit later on, understandably, the risk of bribery in a particular area geographically may be higher than in others. It also may be a higher risk depending on the sector that that agent or intermediary is working in, or the people that he's working with. And so if the risk is higher, then the mitigation, the processes and policies that need to be in place may change. So I think what I would say about that in terms of the sort of takeaway, if you like, is that yes, you need a policy, and I'll talk about it in a minute, and you need to make sure your people know what it is and know how to find it, and it's being implemented, obviously. But a blanket policy may not be appropriate in all cases, because your risk assessments of your geographical delivery areas, if you like, of your services are going to really be the thing that informs what you have to do. And obviously, if an organisation knows that in a particular area there is a heightened risk, or knows in the past that there have been attempts to bribe people associated with it, or vice versa, or people associated with it are bribing people, then that is going to put you on notice that you're going to have to put more of a blanket around it and really think about the measures you need to put in place, training you need to put in place, and due diligence you need to be putting in place. And as you'll come on to see in a moment, one of the areas that the MOJ talked about, and it's common sense really, isn't it? Particularly if you think about the risk of agents or intermediaries who may be more difficult to control, and we all interact with agents and intermediaries in what we do. That's where you perhaps lose a little bit of control because they're not specifically your people. So that's where there may be a heightened risk, and that's why you have to ensure that you've done, or you can show you've done, proper due diligence on those people in the event of something going wrong. And that's what it's really about. It's making sure that you have the procedures, the paperwork, the policies written down, and that you can show that that is being trained out and actually being used in practice if then something goes wrong. Because it's all very well having something written down, but if people don't know about it, and if people aren't actually thinking about it day to day, then you're going to come a cropper really if something goes wrong within the organisation. Penalties. Obviously, when you're talking about these offences, corporates, companies, organisations can't go to prison. Individuals can go to prison, and under the Bribery Act, up to 10 years. And in some cases, organisations who have been prosecuted are fined quite a lot of money. So there's obviously the financial aspect of it. Fines are based on, in very broad terms, a couple of things. First of all, the court is trying to take away monies earned from the activity, if there was activity that generated money. So, for instance, going back to my little Australian holiday analogy, let's assume that the official was tempted by his 4-week stay in Queensland with his family, and he awarded the contract. And the contract was worth gross £10 million. And it all went wrong, and the company was prosecuted. The court would be looking at the £10 million gross, not profit, as the sort of starting point for a fine, because the whole purpose of sentencing corporates is to ensure that they are relieved of, and not in a good way, relieved of the money that they have made from their criminality, because without that, there's no deterrent. There's no deterrent to make sure that corporate entities have the right policies in place. So the starting point essentially is we are going to relieve you of the money you gained from it and not the profit. So there are ways of doing that. Fines which are linked to the value of the contract, they are then increased, multiplied by potentially anything up to 400%, depending on the culpability of the business. And also in relation to financial crime, obviously more generally, you're probably aware there's the Proceeds of Crime Act, so you can have concurrent confiscation process in place, which again is there to strip out any engorgement that the company may have received as a result of their criminality. So you've got large fines, you've got reputational damage. You may be banned from contracts, certainly something that you need to disclose. If you are tendering for business, there are all sorts of ramifications that go wider. It is also for any business being prosecuted, whether it's in the financial crime sector or health and safety or environment, whatever it may be, it takes a long time. It is very weary. It is very debilitating. And you'll find a lot of your people involved a lot of the time in dealing with the lawyers and in dealing with that process. So there's a far wider implication to a business, but ultimately it's about fines, and very large ones, depending on the nature of the company. You may well already be familiar with this case. It's several years old now, but was related to the insurance sector. Sweet, UK-based construction and professional services company. So their PLC, their UK-based PLC, were ultimately prosecuted. They had a international subsidiary company, Cyril Sweet International, CSI. And CSI made payments unbeknown to the UK PLC to a board member of an insurance company. They were UAE based. I think they still exist. They're a UAE based insurer and reinsurance business. They made unlawful payments in order to secure a contract relating to a very large hotel development, for them a £63 million project in Dubai. Those payments were made through a sham hospitality services company by somebody who was obviously associated with the UK PLC. The conduct took place over a 3-year period. CSI, the subsidiary, was obviously associated under the Act with the UK PLC. It was carrying out services on behalf of and carrying out business on behalf of the UK PLC. The SFO learned about it. The SFO carried out a very wide-ranging investigation, which led eventually to prosecution and to their company appearing at the Crown Court in Southwark in London. And the company was fined. Financial penalties in total, just about 2.25 million, which included the fine, which you can see set out there, and a confiscation order. That would have been an order made under the Proceeds of Crime Act. And costs to the SFO, I should say, based on our experience currently, those costs are fairly modest. One expects these days to see cost figures in very big investigations much larger than that. Talked a little bit earlier about reputational damage, and you can see there from the bit that's underlined that any business prosecuted for this sort of type of offending whatever your mitigation is, whatever you want to say about it in court, and obviously in this particular case, the main strand of mitigation was that we were not aware of it. Of course, that's a very big double-edged sword, because you should have been aware of it, or at least you should have been doing things to prevent it. But you can see there that there was a significant reputational impact to them, and a significant financial impact that went far beyond the day at court and the fine and the other financial penalties that were imposed by the court, because their share price fell dramatically. And actually, I seem to remember that eventually they actually shut their operations down in that part of the world. They decided that rather than risk another event like this happening, they would pull out, and they did so at that time. So I talked a little bit earlier about what to do to prevent it. I would hope that you all know in very general terms, rather like I hope Jess and Dan also know in very general terms, what the Birketts policy is on gifts, entertainment and corporate hospitality. I would also hope that if you have forgotten it, you know where to find it, and or it is refreshed regularly so people are aware and reminded about it. And obviously, all organisations do that and hope that their people look at it. So obviously within your organisation, you have a policy in relation to gifts and hospitality, and you're probably well aware that you can't provide or receive any gifts or hospitality under the expectation that it's going to lead to some improper advantage to your company in some way or another. But there are reasonable limits, and obviously we all work in sectors where there is hospitality, there are gifts, and each company can set its own limits as to what it thinks is appropriate depending on the nature of its business. And there's nothing wrong with that, and the law doesn't try and criminalise that sort of behaviour, as long as the level of hospitality that's allowed is reasonable and appropriate for the business purpose, and is designed just to engender good relations. Sort of was talking a little bit earlier about intermediaries and agents, wasn't I? And we have in this business a very large property division, and so they interact with a variety of intermediaries. They might be insurers, they might be accountants, auditors, they might be land agents, estate agents, you name it. And so there is a lot of hospitality that goes on in that sector, but it is really designed to foster good business relations, not to foster corruptly and dishonestly work being channeled one way or another when otherwise it wouldn't have been. So in a very general sense, the measures that you have to have in place have to be proportionate and adequate. And I've set out there just on the slide in very general terms the things, so I'm not going to read them out. You can read them for yourselves, and the slides are available afterwards. The sort of simple steps to avoid a breach and things that you shouldn't be doing. I said earlier it wasn't really about an envelope full of cash. It's certainly not about a suitcase full of cash. And touching on the example I gave earlier, these are some of the examples of things that could constitute bribery if they're designed and undertaken to achieve that improper activity or with a financial advantage in mind. And you can see there donations, meals, travel, entertainment, the usual sort of things that one would expect. And that goes back, as I said a little while ago, and links in with the policies that you have in order to try and mitigate against these sort of events happening. So what do I think in terms of what you should be doing and what policies you have in place? So, as I touched on a little while ago, they have to be proportionate, they have to be appropriate in a very general sense, and that means proportionate and appropriate to the risks within your business. There has to be engagement from senior management. There has to be somebody who is appointed specifically. That would usually obviously be the risk and compliance director or risk and compliance officer, who has this as one of their functions, and that person really should be reporting into senior management. The risk assessment process is the important one for me, I think, because as I said a little while ago, you might be vulnerable geographically in one area and not in another. There might be high risk areas of your practice. There might be areas of sectors and particular types of businesses that you are engaging with, that because of their very nature, maybe a combination of their nature and where they are in the world, the risk of something happening is increased there. So that means your assessment of risk is going to be higher, and therefore the measures that you need to put in place around that are going to be different, perhaps, in a very low risk environment. So you have to make sure that you tailor those policies and procedures. I think the due diligence piece is very important. You have to make sure that there is diligence of those persons that could be associated with you. And as we saw on the earlier slide, that does mean intermediaries and that does mean agents. So you shouldn't be working with, or people shouldn't be purporting to work on your behalf if you haven't done the DD on them, that if you haven't got a relationship with them, if you haven't been able to actually show to your satisfaction their bona fides, because in a lot of the cases, that's where companies historically have got into trouble. And there have been other instances of UK-based insurers and reinsurance brokers getting into difficulties because intermediaries and agents that they are using, they haven't done the right diligence on them. And so there's a weakness and they're exposed. And then if something goes wrong, they're not going to be able to satisfy the Act. They're not going to be able to satisfy the SFO or the court that they had those reasonable and proportionate measures. And it comes back, doesn't it, to training your people, and then having some sort of whistleblowing policy that allows people, if they have concerns, to put forward those concerns in an appropriate way. I hope that's helped. It's a bit of a whistle-stop tour, but that's my part over for now, and I'm going to hand over to Dan, who's going to lead the way for the rest of the presentation. He's going to be talking to you about some sanctions.
Thank you, Matthew. Yes, I'm Dan Irving. As Matthew said, I'm going to speak about sanctions for the rest of the presentation. I'm going to talk about sanctions globally, first of all, with a bit of an overview, and then move on to how they may affect you in particular, what to look out for, the industries that are often sanctioned, and penalties that may apply for breaches of sanctions. So sanctions really can target individual or corporate clients or companies in your supply chain. Because of the constant changing geopolitical landscape, it's important to keep up to date with highly evolving sanctions. New sanctions or adjustments can be made to existing sanctions at any time, and we've seen that in particular with the Russia sanctions. International conflict, terror attacks, or other political developments can cause sanctions to be introduced, but it's important to confront the reality that such restrictions can suddenly close off those markets. So what are they? That's the first question on that slide. What are sanctions? They're really diplomatic tools that are used to promote international peace and security and to combat violations of international law and terrorism. They can be applied against states, non-state entities such as certain organizations, or against individuals. and they really apply economic pressure or restrictions on the regime, entity, or person that they're targeting. So what gets sanctioned? Well, generally they target specific things. They are often put on financials, travel, arms and weapons, commodities, and transportation, in particular shipping, as well as diplomatic restrictions. And then third on that slide is who puts these sanctions in place. Well, they're put in place by countries, national jurisdictions and lawmakers, and also more globally, international bodies collectively implement sanctions. In the UK, the main piece of sanctions legislation is the Sanctions and Anti-Money Laundering Act of 2018. So, types of sanctions. First one on that list, financial sanctions. Financial sanctions include restrictions on designated persons, such as freezing their financial assets, as well as wider restrictions on investment and financial services. They include prohibitions on the transfer of funds to a sanctioned target, freezing government or corporate assets, targeted asset freezes on individuals, such as those associated with terrorist groups. Financial restrictions can also be put in place to restrict making payments to or from a sanctioned person or entity. Then, in terms of transport sanctions, they include restrictions on the ownership, registration, or movement of ships, in particular, and aircraft. And it can include their restrictions on them going into ports, harbours, and airports, and indeed detention of ships and aircraft. And then you've got trade sanctions, trade controls. They can be controls on imports and exports, movement of goods and technology leaving the UK, the provision or procurement of services insofar as they relate to the movement of goods outside the UK, ancillary services, the making available or acquisition of goods and technology outside the UK, and the making available or acquisition of land, conduct of activities relating to military activities, and can apply to the provision or procurement of services. Military sanctions, they can range from arms embargoes to full military operations. Arms embargoes can be imposed on military equipment, ammunition, weapons and technology. They may also apply to some dual use items which can be used for both civilian and military purposes. So raw materials and components can be caught by the sanctions, and they can include items which may be used in the production or development of military goods, such as machine tools and chemical manufacturing equipment. It's all quite technical and often defined within routinely updated regulations. And then you've got diplomatic sanctions, which are political measures taken in order to show disapproval of certain actions, but they often stop short of taking economic or military steps. These might include reducing or removing diplomatic ties, shutting embassies, cancelling high-level government meetings, all tools at the disposal. And then immigration sanctions. The Home Office implements and enforces immigration sanctions, also known as travel bans, which you may have heard of, and those that are subject to travel bans will be refused leave to enter or remain in the UK, and any applications they make for a visa to travel to the UK, including for transit purposes, will be refused. So any foreign national who's subject to a travel ban and who is currently in the UK will have their permission to stay in the UK cancelled, and steps are then taken to remove them. So as a quick overview, these are really on this slide the principal countries that are subject to sanctions. Obviously the most current one, and the one that's spoken about a lot in the news, is the Russia sanctions following the invasion of the Ukraine. But the UN Security Council, those sanctions are implemented EU, US, UK, has the EU exit Russia sanctions regulations. The UN Security Council, though, because they have 5 permanent members and Russia is one of them, have been unable to bring about sanctions on Russia because Russia are a permanent member and have a right to veto. The G7, Canada, France, Germany, Italy, Japan, the UK and the US and the EU, though, have coordinated sanctions on Russia in order to coerce a change in the Putin regime. And these sanctions include financial sanctions, removing Russian banks from the SWIFT system, enabling cross-border transactions, travel bans, banning Russian flights from entering the US, the UK, the EU and Canadian airspace, import and export bans, which include prohibitions on coal, on oil and other energy imports, and banning imports of raw goods like iron, steel, wood, cement. There are arms embargoes, transport sanctions, a ban on exports, sales, supply of or transfer of all aircraft parts and equipment to Russia. Iran has been subject to numerous sanctions, asset freezes and prohibitions to make funds available. There's restrictions on admission, restrictions on equipment used for internal repression, telecommunications equipment, arms export and procurement. Venezuela, subject to the following sanctions: arms export, asset freeze and prohibition, restrictions on admission, telecommunications equipment, restrictions on equipment used for internal repression as well. Belarus, similarly, as a close ally of Russia would veto any UN attempts to sanction Belarus, but they've also been under sanctions from the EU and nations in the G7 since the early 2000s for manipulating democratic elections. So they're subject to asset freezes, travel bans, and other restrictions. China, like Russia, are a permanent member, but the EU have imposed their own sanctions on China relating to human rights concerns, military expansion, and trade disputes. So the EU and the UK have maintained a partial arms embargo on China for its response to the protests in Tiananmen Square in 1989. And then North Korea, heavily sanctioned by the UN and the EU for its continued development of nuclear weapons. They're subject to financial sanctions, travel bans, an arms embargo, an embargo on raw materials, restrictions on energy resources, oil and petrol, transportation sanctions, professional services ban, trade sanctions on almost all sectors of the economy. So far-reaching sanctions. And then here we've got the industries or sectors that are most often sanctioned, starting with the financial sector. They often target the financial sector, targeting finances with asset freezes, preventing banks from engaging with sanctioned entities. Includes prohibiting payments, fund transfers, and financial services to those listed on the sanctions list, the designated persons. The energy and oil industry is often sanctioned. They restrict the export and import of oil from sanctioned countries. Such sanctions can halt or limit the flow of oil, impacting global supply chains, obviously, then, and altering market dynamics, which then has a knock-on effect on everybody. Then next on the list is the technology and communication sector, and sanctions in that area often include restrictions on the export of high-tech goods and services, targeting advanced technologies that could enhance military or cyber capabilities, and surveillance systems of sanctioned countries. Next, I mean, in the field of defence and aerospace, sanctions can include arms embargoes, restrictions on dual-use technologies, limitations on technical assistance impacting import and export of defence equipment. The agriculture and food industry is often sanctioned, and that can significantly impact agriculture and food industry by imposing restrictions on imports and exports. Again, they often target specific countries or entities, limiting their ability to import or export essential food supplies. Again, has a disruptive effect on global supply chains and availability of key food items, both domestically and internationally. And then shipping and maritime sanctions often impact on this industry, targeting shipping companies and cargo. Might include restrictions on vessels, prohibiting ships owned or operated by sanctions entities from entering ports, and cargo bans banning the transport of specific goods to and from sanctioned countries, such as oil or arms, or again dual-use technologies, and the flagging and reflagging restrictions, which limit the ability of vessels to change their flag state to evade sanctions. So all of these measures aim to prevent the illicit movement of goods and ensure compliance with international regulations. So this one is really designed to be a little more specific about what the sort of things that you might need to know. In particular, the first aspect is where insurance providers could be exposed to sanctions, and I think, like other regulated businesses, insurance companies need to conduct sanctions screening throughout the transactions and processes with clients. When an application is received, if a party is changed or added, when a claim is presented, and indeed when the claim is paid, it's crucial really that insurers and reinsurers are aware of their exposure through the policies they have in place, especially those related to international trade, like shipping. Non-compliance could lead to severe penalties and consequences. An area of concern in marine insurance and similar transportation policies, because they're considered among the most exposed to sanctions risk. For example, insuring tankers carrying Russian oil could lead to a violation of sanctions imposed on Russia. And an insurance company in the EU, UK, or the US should conduct careful KYC, know your customer checks, when considering coverage in high-risk areas like transportation. So every governing body provides full guidelines for their sanctions programs online. I mean, I've got the UK sanctions guidance up on my screen here, and you can look at that on the government website, and that's the sort of thing that you should have to hand and be aware of. But the sanctions lists for each jurisdiction are regularly updated, and whilst broadly similar, there are often differences between them, and multinational companies need to be aware of restrictions for each of the jurisdictions in which they operate. So how to check for sanctions? As I say, there's guidance on government websites, and on those websites the designated entities are listed, and these lists include the target's name, alias, known identification details like address, date of birth, passport number, and other information relevant to their identification. Of course, sanctioned individuals may sometimes try to use aliases to avoid detection. So when possible, national sanctions lists include those to help you identify targets with greater accuracy. New clients should be screened for sanctions as part of the onboarding process, and existing clients and third parties should also be screened on a regular basis in order to comply with that ever-changing landscape. It's constantly being updated. Partial ownership is another area that you need to consider. America, for example, the OFAC operates a 50% rule. It's a mechanism employed to address situations where sanctioned entities attempt to evade restrictions by hiding behind complex ownership structures. And that rule stipulates that if a blocked person or entity owns 50% or a greater interest in another entity, then that second entity is also considered blocked, regardless of whether it is explicitly listed within OFAC's list of specially designated nationals or blocked persons. In the UK, as set out in UK financial sanctions general guidance, an entity is owned or controlled directly or indirectly by another person in circumstances where either the person holds directly or indirectly more than 50% of the shares or voting rights, or the person has the right directly or indirectly to appoint or remove a majority of the board of directors of the entity, or it is reasonable to expect that the person would be able to ensure the affairs of the entity are conducted in accordance with that person's wishes. So it's important to properly analyse that individual's controlling influence. And of course, you need to be aware of the level of ownership that applies when making that assessment in the jurisdiction that you're working with. And then particularly relevant to the US, well, they have secondary sanctions. So, and that's where companies outside the US and UK companies need to be aware that they can impose secondary sanctions against those doing business with entities that are sanctioned by the US. So even though a company might not be sanctioned in the UK, or an entity might not be sanctioned in the UK, if they're sanctioned in the US and you do business with them, then secondary sanctions may be applied, and they can be enforced even where there's no nexus that actually involves the US, such as use of its currency or export or import of its goods. So, for example, OFAC maintains secondary sanctions against anyone dealing with the Islamic Revolutionary Guard Corps. So anyone in the world dealing with assets linked to IRGC, even those with no US connection, can be restricted or prohibited from accessing certain parts of the US economy, including the financial system. And there are more than 2,000 individuals flagged for secondary sanctions by the US, most relating to Iran, but also North Korea, Russia, China, and the Lebanese Hezbollah party. Moving on then to a bit of a case study. It's a US case, this one, but it's an insurance case, and therefore on point, and it relates to privileged underwriters reciprocal exchange, Pure. In 2010, Pure issued a private fleet car insurance policy and a jewelry and art insurance policy, and two high value homeowners insurance policies to a company called Medallion, who were based in Panama. And Victor Vekselberg was identified as Medallion's sole shareholder in February of 2010 in response to a questionnaire form that Pure had used to confirm that the insured properties were not used for commercial purposes, so one of their compliance forms. And in 2018, OFAC in the US added Vekselberg to OFAC's list of specially designated nationals and block persons, and therefore, owing to the 50% rule that they apply, any entity owned by Vekselberg, of which Medallion was one, became also a blocked person on that date in 2018 and remains so for the rest of its relationship with Pure. And Pure collected 38 premium payments, totaling over $300,000 after they became Medallion became a blocked entity by virtue of the 50% rule between 2018 and 2020, and then also paid out a $7,500 claim in 2020. And in so doing, in engaging in those 39 transactions with a blocked person, they were held to violate the Ukraine-Russia related sanctions regulations in the US, and were fined $466,000. So on this slide really are a few things to look out for, red flags as they're said to be here. Things like client being overly evasive about the source of money, intentionally hiding information and not revealing details about themselves, additional parties being involved in the transaction for no apparent reason, the client having their wealth stored in bank accounts across a range of countries, the client's economic profile not matching the transaction, and the client using complex corporate structures and shell companies to hide the true ownership of the funds and assets. or potentially seeking to avoid detection under the sanctions. So really what you need to do is check if a new client is on the sanctions list. And if an individual or corporate entity is under a sanctions list, the account or transaction must be suspended, and you must report it to the relevant compliance manager in the firm, because failure to do so constitutes an offence. So for the most serious breaches of financial sanctions in the UK, a criminal prosecution may be considered. There are other means of enforcement available and more often used, but for the most serious of cases, criminal prosecution might be instigated, and it carries a maximum sentence of 7 years. But there are more regularly deployed civil and criminal enforcement options to remedy said breaches. The Policing and Crime Act 2017 contains powers for the Treasury to impose financial penalties under Section 146 of that Act for breaches of financial sanctions. And the monetary penalties regime created by the 2017 Act provides an alternative to criminal prosecution for breaches of financial sanctions legislation in the UK. And the Office of Financial Sanctions Implementation, the OFSI, which is part of the Treasury, they're the body that impose those financial penalties. So under Section 146 of the Policing and Crime Act 2017, the Treasury may impose a monetary penalty on a person if it's satisfied on the balance of probabilities, because it's a civil enforcement regime, that the person has breached a prohibition or failed to comply with an obligation that is imposed by or under financial sanctions legislation. So it's that lower civil standard on the balance of probabilities that they've breached the sanctions, as opposed to beyond all reasonable doubt. Where it's possible to estimate the value of the funds or economic resources, the permitted maximum financial penalty is the greater of £1 million or 50% of the estimated value of the funds or resources. Where not possible, i.e. in any other case, the permitted maximum, it is only a maximum of course, is £1 million. So high fines. So that really brings that section to a bit of a close, and as Matthew outlined at the beginning, we've got a little bit of time for some questions, and otherwise we're happy to take some by email and respond afterwards.
Thanks very much, Dan. Thanks, Jess. Nobody has put any questions I can see in the Q&A, which means you've either all been very entertained or all gone to sleep, or maybe a bit of both. We're very happy. These are not easy topics to get your head around early in the morning, so we appreciate your attention. And as Dan said, if there's any follow-up from any of you, our details, not only does Beverly have them, but obviously you can find them on the internet, and they're on the slides in any event. So if nobody has any questions, I think we'll let you get on with your day. Thanks very much for joining us, and I hope you found that informative. And it was a pleasure to speak to you all this morning. Thank you very much indeed. We'll close the webinar now.